Today's presentation is on front of package labeling on food products. During the presentation, I will explore the current debate between legal and health policy scholars on the extent of First Amendment protections afforded to food companies that use misleading advertising on front of package labeling, namely in response to a 2011 study released by the Prevention Institute that questioned whether front of package labels on food products marketed to children contained misleading or deceptive speech. I will first address the concern why food labels are of interest today. I'll discuss the status of food labels in the marketplace, then discuss the First Amendment implications, and also the consumer's right to know. We'll conclude by referencing case precedent. The debate between nutrition policy and legal scholars is not just a concern for a free marketplace of ideas, but of public health. The obesity risk has become a major concern for the food industry since the World Health Organization recognized obesity as a problem of epidemic proportion. We can see here that cost of treatment related to obesity is estimated at $117 billion. Governments have tried to curb the epidemic by regulating how food is marketed to consumers. Certainly, the literature indicates that we're vulnerable to the effects of advertising, so it seems that the government would have a substantial interest in regulating this kind of speech. Both nutrition and public health scholars have argued that we must take another look at current interpretations of the First Amendment, suggesting that free commercial speech is equivalent to free political or religious speech. It certainly is not the case anymore when public health is concerned. The Nutrition Facts Panel was required for every food package under the provisions of the 1990 Nutrition Labeling and Education Act. Manufacturers argued that since they were required to put potentially negative nutritional information on their foods, for example, the number of calories or grams of fat, they should also be allowed to point out their products' positives. Since then, there has been an increased focus on front-of-package labeling by the FDA, public health advocates, and the food industry as a whole. The problem is that these food labels are more of a marketing ploy than legitimate information. The FDA and the U.S. Department of Agriculture's Food Safety and Inspection Service stated that the concern is whether front-of-package labeling systems use criteria that were not stringent enough to protect consumers against misleading claims, were inconsistent with the dietary guidelines for Americans, or had the effect of encouraging consumers to choose highly processed foods and refined grains instead of fruits, vegetables, and whole grains. We can see here by these news clips that the media have definitely been responsive. This brings us to the Prevention Institute's findings. Prevention Institute examined whether the front-of-package labels on grocery store products marketed to consumers promoted foods that were helpful or unhelpful. Its findings indicate that the nutritional value of products containing manufacturer-developed front-of-package labels did not meet one or more nutrient criteria for total sugars, fat, saturated fat, sodium, or fiber. The study emphasized that the current system, which allows food companies to decide what information is included on their front-of-package labels, does not work. The FDA is developing proposed regulations that would define the nutritional criteria that would have to be met by manufacturers making broad front-of-package label claims concerning the nutritional quality of a food, whether the claim is made in text or in symbols. However, some scholars do believe that an outright ban or heavy regulation of front-of-package nutrition and health claims would violate the First Amendment. And here we're talking about commercial speech. It's true that marketing, much like the speech of political candidates, is a form of advocacy. As such, it usually will present only one side of an argument. That fact standing alone, however, does not categorically categorize them as inherently misleading. Indeed, if marketing strategic selectivity were to render it inherently misleading, the whole concept of commercial speech protection. The FDA stated in a 2002 Federal Register notice False or misleading claims concerning foods may harm individuals who rely on those claims. Truthful claims, by contrast, may improve public health. As the recognized arbiter of truthful statements about regulated products, the FDA for many years has been supported in the courts. However, recently, the FDA has encountered opposition to what appears to many as the FDA's chilling effect on freedom of. To best argue that the FDA has the constitutional right to regulate but not prohibit speech of front-of-package labels can be supported by an analysis of Parson v. Shalala, a landmark Court of Appeals decision that challenged the First Amendment validity of FDA regulation. In this case, the court makes it clear that the First Amendment disarms the FDA of any power to ban health claims unless the FDA has solid evidence that the claims actually mislead. However, after Parson, the FDA is now required to demand, if a claim is in fact inherently misleading, be corrected through a decision. The following discussion illuminates how the new mechanism born out of Parson permits food manufacturers to use their own discretion when using front-of-package labels while permitting the FDA to regulate without fear of speech suppression. In the Parson case, the FDA didn't have power to ban health claims. Now the question remains whether the FDA has the right to ban nutrient content claims on front-of-package labels. Among other FDA requirements, a disclosure statement is needed if a nutrient content claim is made and another nutrient in that food exceeds certain prescribed levels. An example is a no trans fat claim made for a product high in saturated fat or sodium, which would require a disclosure statement identifying the high levels of these other nutrients. This is exactly what the Prevention Institute study found. While the front-of-package labels are not false, they misrepresent all nutrients found in a particular food product. Thus, consumers are misled. Why front-of-package labels can't go unregulated? The increasing prevalence of obesity throughout the United States has led policymakers to rank it as a critical public health threat. It is the issue of government interest. Thus, front-of-package labels that mislead consumers pose enough of a consumer health threat that regulation is necessary to ensure consumers are given the right to make helpful decisions. The landmark victory achieved in defending freedom of health speech in Parson found that the FDA restrictions were a violation of the First Amendment. What the decision also means is that the FDA is under a legal obligation to permit consumer access to truthful and non-misleading health claims and to potentially misleading health claims accompanied by reasonable disclaimers. Thus, the potentially misleading claims, as found on front-of-package labels, are open to FDA regulation without violation of the First Amendment. Consumers have many reasons for wanting information about the foods they eat. The First Amendment should be held up to its original purposes and ultimately aid in our search for truth about the foods that we eat. Thank you.